Supreme Court of Florida is now in session. Please be seated.
We now move to the third case on today's docket, State of Florida versus Ivey.
May it please the Court, Virginia Harris on behalf of the State of Florida. I previously reserved 5 minutes for rebuttal. The case at bar involves a jury selection issue, and it's specifically about whether or not a defendant who abandoned a claim to the state removing a juror by peremptory challenge revived that the next day when he requested a continuing objection after he agreed to excuse the jurors. And basically what happened is after this occurred, the defense attorney objected and the judge allowed the state to remove this juror. The defense attorney, they were all at sidebar, and the record indicates that the defendant himself was at sidebar and actively involved in this process. The defense attorney then asked to confer with his client at the table so that he could point out the jurors to the defendant. He then informs the court that the defendant himself agrees to and accepts the jury panel. The judge then asks again if they agree to the jury panel. Defense counsel says yes. And the judge asks if they agree to excusing the jurors that were not selected. And defense counsel indicates he has no objection to excusing the jurors. The next day, when they come in, right at the beginning, the judge says, he indicates that he wants to state for record purposes that juror 46, who is the juror at issue, was removed by use of a peremptory strike and not a for cause challenge. So the judge was not asking defense counsel how he felt about her. He said he wanted to make this clear for the record. He then says, is there anything else that the parties would like to raise? Defense counsel says as follows: Your Honor, the only thing other than everything you said is fine. What I would like to do, I've made a few objection in preliminary proceedings and objected to evidence and objected to different things. I would like to just make that as a continuing objection so they don't come back and say we failed to object in the trial. So when this claim was raised in the First District, initially, 2 judges in the majority opinion ruled that defense counsel had renewed his objection or revived it, whichever way you want to look at it, when he requested this continuing objection.
Was one of the things that they objected to was the peremptory challenge of the juror?
You mean when he requested the continuing objection?
No. So he says, I want to renew my objection, I want to continue objection for the things I did in the preliminary proceedings for evidence and other things. Wasn't one of the things that he objected to was...
Oh, I'm sorry.
Wasn't one of the things he objected to was that the juror had been, a peremptory challenge had been given for that juror?
Yes, but he then abandoned it multiple times.
I understand that, but wasn't
Right.
one of the things he objected to those
Right.
things? Okay.
And then...
Isn't the point of the contemporaneous objection rule in part to put the judge on notice? In other words, the trial judge needs to know what the trial judge needs to rule on, right?
Right.
Here, the trial judge said, any prior rulings that I've made, there's a continuing objection, something like that. I'm not exactly quoting, but something like that.
Yes, but...
Was this did one of the prior rulings that the judge had made, include this, the
Right.
ruling to allow the peremptory challenge to go forward?
That is true, but if you interpreted it that literally, it wouldn't make sense.
How else do you interpret language other than literally?
Because the judge also made rulings in the defendant's favor. See, the defendant did motions in limine, motions to suppress, motion to dismiss, and if you took the judge literally to say, I recognize a continuing objection to any ruling made by me, then the judge would be saying that he recognized an objection to even the rulings he made in the defendant's favor.
Right, but those aren't going to be appealable.
Right.
We don't have to worry about those.
But, and then also, kind of as a secondary issue in this case, defense counsel had agreed that the juror could be excused.
Well, we'll talk about that in a second.
Right.
But with regard to that, as I understand the sequence of events, and I just asked you those questions, one of the prior rulings and different things or rulings that have been made was this. The judge said that you have a continuing objection regarding those very things. How is that different than what we approved of in Joyner with renewing versus continuing, or I accept subject to?
Well, because in this situation, as I mentioned, the defense attorney, I think, is excluding juror 46 from his request for a continuing objection, because the judge, and I have attached the record specific.
But if you just agreed with me that one of the prior different things was the objection to juror 46, and any prior ruling included juror 46, how can then those same things be excluding juror 46?
Because he says, this is right after the judge mentions juror 46, Your Honor, the only thing other than everything you said is fine.
Well, but everything the judge said was fine. So what happened is, and I've done this before too on the bench, the judge came up and I'm sure the judge had a thought overnight and said, I just want to make sure this is clear. Comes back in the morning, first thing says, I just want to clarify, this is what happened. And the judge was completely accurate. There was a peremptory challenge, there was a Melbourne objection, and I overruled that, and I seated the juror, I granted the peremptory challenge. I allowed the peremptory challenge to go forward, and the next juror was seated. That's what happened. That's fine. But then he says, I just wanted for the record to preserve all of my prior objections, right?
Right.
Did he say preserve, or did he say I want a continuing objection?
He wanted it continuing.
And I mean, isn't a continuing objection, I mean, the whole point of that is I want to not have to object again when this comes up?
Right, but
How can that be reasonably understood by the trial judge to mean to apply to something that will never come up again?
And that's something that I mentioned in my brief, that he says, so it doesn't say we don't object again at trial. A juror selection issue is not going to come up again at trial.
This is the question I have for you.
Okay.
The difference here is you have a situation where the night before, the judge then says, we're going to impanel the jury. Does everyone agree to the jury that now is seated in the jury box? State says yes. Defense counsel says, I've gone over the entire panel, and he agrees and he accepts this jury. And now we all know that trial counsel has the ability to say, we agree with the condition that we continue our objection to the exclusion of juror 5, 6, 7, whatever the juror is that's been excused, correct?
Correct.
So once that happens, is there any more continuing objection that needs to happen?
No, I don't think so, especially when you add that he went even further than that and said he didn't object to the judge excusing the jurors that weren't selected. And so it wasn't just that he agreed, he makes it clear.
Counsel, how many peremptory challenges did the defense have left?
I'm sorry, I don't recall having.
Let's assume for the moment the defense had one in the pocket left over. If in the morning the transcript didn't read like this, the judge said what he said, or she said, and the defense counsel said, Your Honor, I have one more peremptory challenge, and I am using that peremptory challenge on juror number 54, who was the new one seated. The judge would have to honor that, wouldn't the judge have to, even though all the jurors have been excused, right?
Right.
And that's because our law is clear, and I think somewhere along the line someone cited about, there's a bunch of cases that until the jury is sworn, this thing is not locked, right?
Well, it does say that, but.
So excusing the juries is not, at least under our law right now, and maybe that should change, but at least under our law right now, has no significance until the jury is sworn, correct?
Right, except that we are arguing that it should be distinguishable when a defense attorney actually agrees that the jurors can be excused, especially since in this case, his complaint is that someone that he wants to be on the jury is not on the jury. So the judge can't cure that error anymore.
When exactly was the jury sworn? Was it the night before?
In other words, they went through the process, and then the next day, when they arrived after this discussion, the jury was sworn.
So the day before they left, when the judge asked the question, he asked them, he read the names of all the selected jurors that he believed everybody agreed on.
Several times.
And I asked if they were agreeable, and both sides said yes. Had he sworn the jury at that moment, we wouldn't be here today.
That is correct.
Correct?
That is
so
correct.
The judge waited until the next day to swear the jury. I just wonder if he had not asked the question, the judge, is there anything else we need to address this morning before we bring in the jury? If he had not asked that question, I'm just wondering if there had been no reason for counsel to say, I just want to renew whatever.
Yeah.
That would have been the end of it.
Exactly, but I think based on his language, at the context, the defense attorney is indicating that his request for a continuing objection doesn't include that. I disagree with Justice Luck about that. If a reasonable attorney, pretend this is your case, for example, and you have just expressly abandoned an objection and accepted a jury and agreed the jurors had been excused, would you attempt to revive it this way? Wouldn't a reasonable attorney come in and say, wow, listen, I know that we said we agreed to the jury yesterday.
But counsel, under Joyner, if the attorney had said, instead of saying the continuing objection, what he said, I renew all my prior objections, that's it. That we wouldn't be here. That would be sufficient, right?
Well, I mean,
So I guess my question to you is, the answer is yes, that would be sufficient. The answer, what I have an issue with and what I'm struggling with is, and I'd love for you to address it, is why is those 4 or 5 words perfectly fine to preserve this, but the much more words and the trial judge's acknowledgement of any prior ruling, not sufficient?
I don't agree with you that when you just say, I want to renew objections after you abandon something, that's sufficient. I do not agree that a trial judge or the parties below still consider something that was resolved or abandoned to be an outstanding issue. And that was what the policy argument that I was discussing, is that in this case, if you allowed this to happen, what you would essentially allow lawyers to do is to invite an error, tell a judge, I agree to this. To this jury panel, I agree that they can be excused, and then come in the next day and make some vague request for a continuing objection when I argue that the language before indicates he's not even talking about juror 46, and then, which really doesn't put the trial court on notice that you're specifically talking about that.
Those are two different issues. I think you're saying even if he had come in the next day after the jury was excused and he was waived, you think the rule ought to be that he can't make, even if it had been a specific objection, that would not be sufficient.
Right, that is a secondary argument.
But we don't have to decide that to decide this case from the state's perspective.
That is correct. That is correct.
But we have ruled back in, I don't have the case here with me, but back in 2009 in Murray versus State, that objections has to be specific to preserve the record. I know this is kind of a friendly question to you, but the magic words are not required, but it must have been sufficiently precise that it fairly appraises the trial court of the relief sought and the grounds therefore. So, I mean, I have let's say this is not one of these Melbourne things. It's just a regular judge made a ruling on a challenge for cause or something down the road. To preserve that, the counsel needs to ask for more peremptory challenges, I believe, on a challenge for cause that's denied, more challenges, and then has to object at the time that the jury is about to select it, and I believe raise it again when the jury is sworn. You have to jump through all these steps, you have to take all these steps to properly preserve that. And here, I think the argument is being made that you can judge out just kind of like a deposition objection where, object to form, and that covers everything. I don't know that Murray allows that.
Well, I would point out the language I discussed in Caratelli, that the reason for having defense counsel raise 2 objections is twofold. That the defendant is supposed to be given more time to reconsider his position, which is important because oftentimes when you're fighting with the prosecutor over something, you don't have time to talk to your client about it and see how he feels. And the defendant himself is often the reason defense attorneys change their minds about objecting to certain jurors. The other thing is so that the judge has the second attempt to cure the error. But
have you ever seen in any transcript, you're an experienced appellate attorney, have you ever seen in any transcript where there's that standard, Your Honor, we accept the jury subject to any prior objections, where the judge said, you know what, you just said that, I'm going to go back in my ruling on one of those things. You have one of those?
Only if the defense, and I'm actually a rather experienced trial attorney as
Right.
well. The only time I see trial attorneys go back on their rulings is generally if the defense shows up with something to show them they were wrong, which they could have done in this case.
Right.
Since it was the night before, you could have gotten the Dorsey case.
I want to talk about the question Justice Labarge asked you. Here, at least under Murray, when this first came up as a Melbourne, there's no question that this was a properly raised Melbourne challenge.
Oh, you mean in terms of his original,
The original objection.
Yes,
In other words, there was a clear contemporaneous objection
Right.
that was well spelled out and articulated.
correct.
That's not the issue.
That's not the issue.
The issue is simply, did they re-raise it to say, we renew our objection that we made earlier, which would have been perfectly fine, or is this continuing objection language sufficient? That's the question, right?
Yeah, and I don't think it is, especially, I don't think it's clear at all. If I was a judge and I mentioned juror 46 and a lawyer said, I want to raise something other than what you said is fine, and then requested a continuing objection, I would not think, that definitely would not put me on notice that he was re-raising juror 46, especially after abandoning it so many
Well,
times.
And that's isn't that the important point? I mean, we're focusing, if there's three things that happen, it seems like some of the questions are focusing on the first thing, i.e. the objection to the juror, and then the third thing, which is this arguably, vague statement about, my continuing objection. But your point is there was this clear break where it was abandoned, and so we don't really need to get into sort of, from your perspective, we don't need to get into the question of, as a general matter, is it enough to say, I renew my objections that I made before, or if I have to list them out specifically or whatever?
You wouldn't have to. You could resolve it. The reason, and I got to stop soon because I'm getting into my rebuttal time, is I have concerns about attorneys raising an issue, then taking it back or resolving it. And then all of a sudden, at the end of a trial, being able to say, oh, by the way, I renew all of my objections, and being able to claim on appeal that they're talking about that issue that they abandoned because the parties in the trial court no longer consider the issue that you settled or agreed to be an outstanding objection.
Isn't this easily resolved simply if, and I think Justice Labarge asked the question of, if the jury had been sworn immediately after they said, all right, you can excuse the other jurors, all right, those of you remaining, raise your right hand, you swear to be good jurors, yes, I do, that's it. Then we wouldn't be here for that.
Yeah, that's true.
That's the fix is not to reconfigure continuing objections, but to just advise trial judges to swear them in after the jury selection's done, right?
Right. Well, no, I don't think that what took place here was fair. Judges have indicated to me in the past that the reason they do that is because they want to avoid declaring a mistrial if something happens in the interim. That's what I've been told.
Well, they want,
But-
I think the state wants to avoid jeopardy being attached.
Yes, exactly. And so that's
the
why.
reason, because things happen overnight.
Right. Thank you. Would it be okay if I reserve the remainder of my time for rebuttal? Or do you want me to? Okay, thank you.
Morning. And to our new justices, welcome to Tallahassee.
Thank you. I have a question for you. One of my concerns is I want to make sure that preservation issues are not eroded. And to me, this is an important concern because normally, traditionally, once a jury is selected, it's not sworn in, but you have the obligation, if you want to re-raise any objection you have to anything that happened prior to, with regards to the voir dire. In this case, defense counsel did not do that. So my concern is what happens now, because really you're supposed to do a specific objection. You're supposed to tell the trial court, this is the problem. So when it goes up on appeal, the appellate court understands what the actual objection is. And a continuing objection, I understand, but normally that happens in a case of, let's say we're having a discussion about hearsay or relevance, and instead of saying, Judge, I don't want to have to get up 10 times, can I just have a continuing objection on hearsay or relevance? Yes, absolutely, it stands. So that's normally, traditionally, what it means under the law, a continuing objection. So here, how can we, if this is allowed to stand, this opinion, how do we go about preserving the issue of preservation, of making sure that it's not eroded?
Your Honor, in this case, this court can rule on the very narrow, very specific facts of this case that the objection was renewed. And that won't throw open the doors for eroding the preservation of error doctrine.
But how can you say that when there wasn't anything, when you read the transcript, it's very minimal and very bare. How is there a possible renewal? How can you, I mean, if you're going to do a renewal like that, then you have to say, you're correct on that, Judge, and I made a mistake, and I am renewing my objection. I'm taking the jury as is, with minus the exception of the exclusion of jury number 46.
It certainly would have been better for the defendant if that's what had happened. We wouldn't be here, obviously. But it's not required because...
Well, but how can a judge in this context understand that there's a resurrection of this abandoned objection concerning the peremptory challenge when the judge has just laid out what happened on the peremptory challenge and defense counsel says everything you said is fine? How could a judge possibly think that that objection with respect to the peremptory challenge is being resurrected?
Your Honor, because
If
I
it's
think
fine.
the way that Justice Luck was looking at that language was that
Well, I think I may be the only one looking at it that way.
the judge came in the morning and he said he wanted to put on the record to make sure that it was clear that juror number 46 had been a peremptory challenge, not a for-cause challenge. He recognized that as an appellate issue that could be raised. And the fact that Mr. Green, the defense counsel, said, everything you said is fine, means, yes, Your Honor, that's what happened. He was affirming what happened.
Well, you know, it would be one thing if he had said that is correct. But fine is different from correct. I think fine means we're good with that. And furthermore, how do you address this distinction between a continuing objection, which has to do with matters that may continue to be arising, as opposed to an objection with respect to a juror, which is, that's once the juror's about to be sworn, then that's over. That's not going to be coming up in trial.
Well, Your Honor,
that's the context here of what this vague renewal of objections. The context is a continuing objection, right?
the court is really focusing on picking at the specific words that were used by defense counsel.
Isn't the matter of preservation a matter of formalities? Now, it might not be magic words, but it is a matter of some words, and there is an element of formalism that is inherent in the idea of preserving an objection. Isn't that correct?
Certainly, Your Honor. Some words have to be used. And this court has said that the right to an impartial jury should not be subject to an arcane maze of reversible error traps. And that's what it looks like this court is heading towards in requiring...
This is, to me, is not some magic word test. It's a matter of plain English. When you have the juror issue raised by the trial judge with a very specific identification of what's on that trial judge's mind as a possible issue. And then the defense counsel says, everything you said is fine, but then goes on to say, the only objection the trial counsel mentions has to do with some other objections in preliminary proceedings and objections to evidence, and making that as a continuing objection. So when I read that, I think, okay, there must have been some motion in limine made. Was there a motion in limine made?
Yes, Your Honor, there was.
Okay, so you got a ruling in that, and so this trial judge doesn't want to have to the trial defense counsel does not want to have to continually make objections when that evidence comes in regarding the motion in limine in the course of the trial. In that context, it would be an appropriate continuing objection, it seems to me. That has nothing to do with the juror issue.
Your Honor, the defense counsel objected not only to, he said, I've made objections to evidence and different things. So clearly he was referring to something other than just his evidentiary objections. And furthermore, The trial court, the judge, in response to that said, "I will state for record purposes any ruling that has already been made by me. I recognize Mr. Green's continuing
But that's in
objection."
response to the request by the defense counsel for some kind of continuing objection.
But if you look at this in context, it starts off, it says, Your Honor, the only thing other than, which it seems to me, the judges, and that comes right after the judges talked about the history on the peremptory challenge. So, and then he says, everything he said's fine. So with that other than, it seems like he's pivoting, he's pointing, this is going to be something different than what you just talked about. I don't know how a person could look at that and have a conclusion other than that.
Your Honor,
It's other than, the only thing other than. Other than what? It has to be other than what you just talked about.
Your Honor, he never completed the thought, and the question
Well, he
is
did.
very valid. The only thing other
He's not the
than,
most articulate, I will grant that, but this is in trial and those things happen, just as they do here, but it seems to me, when you look at that all in context, I'm struggling to understand how the judge would have ever had any idea that they were trying to resurrect this abandoned objection with respect to the peremptory challenge.
I'm concerned by the same concern that the Chief Justice mentioned earlier. Having sat as a trial court judge for 13 years, 5 in criminal, I noticed that this whole formality that I believe the law requires for preserving issues during a trial for appellate review later, it's just going down the drain. I mean, and where I sat I counted 21 cases where the state did not even prove venue. That's a one-sentence question. And then when you call them on it, because they didn't prove it, then we have to do what we're doing now. We have to reconstruct what everybody meant. But all I have to do is just do it. The question here, listen to his preservation. I made a few objections in preliminary proceedings and objected to evidence and objected to different things. Now, that's likened to a compound question. If you answer, how is the judge supposed to know which one he's talking about? If a judge says yes to one, he meant yes to all. Why can't he just come out and say, Your Honor, I objected yesterday to this juror's peremptory challenge. This is the reason why I objected. I want to make sure the record's clear on that. Okay, denied. Thank you. Wouldn't be here. But that seems to be eroding in the practice of law. Everybody's just skipping over things, and I think we need to put the brakes on that.
that may very well be true, Your Honor, going forward, but certainly the trial lawyer in this case.
You're well preserved.
Yes, the trial lawyer in this case was entitled to rely on the court's, what's the word? The court's assurance that any ruling.
But you agree that if once the trial court said, I just want to make it clear, if at that moment in time the defense counsel had said, yes, Your Honor, and I made a mistake and I should have objected to the striking of juror number 46, you agree that would have been a clear objection?
Yes,
And we probably would not be here.
we would not be here.
Counsel, I want to ask you about the joiner rule a little bit.
Yes, Your Honor.
So you do this for a living. I imagine you understand how these rules work. If this was an evidentiary objection, do you have to, at some later point in the trial, give a specific and contemporaneous objection to the evidence, and then later renew in a specific and contemporaneous way? Or just the single objection is sufficient in evidence?
My understanding, Your Honor, based on the cases that have been cited, and in the Murray case, for example, if there has been a specific contemporaneous objection, then it can be a continuing objection throughout the trial, so it doesn't have to be raised.
You can raise it once.
Yes, Your Honor.
Let's talk about suppression. So if you move for suppression, you have a suppression hearing, you file a motion, a judge makes a ruling on that, suppresses certain evidence, that's preserved.
Yes, Your Honor.
Okay. We have a special rule for jury selection where you get to make a specific and contemporaneous objection. It's significantly litigated in Melbourne by going through all 3 steps, which somewhat happened here. Then there's some activity that happens, And then, at the end of it all, you have to say, I renew my objections during jury selection. And only then do you get to pass through and get to come to this court and argue, right? That's the way the rule works?
That shouldn't be the way the rule
Right.
works.
What's the logic of joiner? What's the logic of requiring, forget the abandonment here, because that's a problem for you too.
Right.
But if without abandonment, what's the point of having this, we renew our objections, this formality, or we accept subject to, which is what I normally heard it as, and I'm sure you've seen it a million times, and the judge says, okay, fine, and goes on with their business. What's the point of this?
What the court has said is that the purpose of that additional requirement is that something may have changed, and this is what the state argued as well, that something may have changed.
Why is that not true of suppression, where a client may say, you know what, I really want that evidence in? Or why is that different for an evidentiary objection, where, you know what, you objected, but I really want that in because it seems to be kind of helpful to me, or I think that's okay? Why is that different for anything?
That actually happened in this case, that there was a motion to suppress, and later the defendant decided it was okay to let the
You can do a
evidence
motion
in.
to suppress. You can say, I'm going to take a plea, but subject to the appellate review of the denial of my motion to suppress, correct?
Yes, Your Honor.
But you don't have to preserve it again. You don't have to object again.
Right.
I'm having trouble understanding why we're even talking about this second hurdle, where we're debating the intricacies of the word continuing versus the word renewed, when there was a perfectly good objection on the record here.
I am 100% with you, Your Honor, because...
Well, I don't know where I'm at. I'm merely asking.
Yes, I understand. If I ran the zoo, and if I made the rules, I would say once you have made that objection, that should be all that's required. You should not have to go through the magic words, follow this arcane maze of reversible error traps to preserve that error. And I'll tell you why. Because the rights that are involved here are so important that we're talking about not just the defendant's right to a jury trial that is not tainted with racial discrimination, but also the right of this individual juror to sit on a jury, to be part of the judicial process without being dismissed based on race or ethnicity or gender. And that's what happened in this case.
But from the defendant's perspective, isn't it the case that we could go through a process like this of selecting a jury, and you may have an objection, it may be a good objection, but when you get to the end of the process, you're looking at that jury, and you're saying, that's a pretty good jury. I think I like that jury. And I don't want to get back into upsetting this, because I think this may be the best jury I'm ever going to get. And therefore, you don't renew the objection. And that sort of thing can happen, and where you're happy with the jury. As a practical matter, doesn't that happen that way sometimes?
Yes, Your Honor, that could happen, and it would happen
If that does happen that way, where the defense is happy with the jury, why should we have this process that just because they were unhappy earlier, that they've got built-in reversal on appeal if they end up being happy before the jury, right before the jury's sworn?
In most cases, it shouldn't. That should not lead to reversal. However, in this case, the timing is really important, because this wasn't a case where this was one of the earliest jurors and then all kinds of different jurors paraded through the courtroom and the defense was then happy. What happened was juror number 46 was the very last juror who was excused. The defense attorney knew then who the next juror was, and nothing changed. That was the end of the day, and then they came back the next morning, and the very first thing that the trial judge said was, I want to talk about juror number 46. I want to make sure that that was a for-cause, not a for-cause, a peremptory challenge, and I found a race-neutral reason. So there was no reason here for the defense to have changed its mind. And so this would be, as I said earlier, a very narrow case where on these facts, the court should approve the decision of the First District Court of Appeal.
To me, this record reads as if the defense did change its mind, because the defense said that I've reviewed this with my client and we find this jury acceptable. My client and I both like the jury as seated. The judge reads out all the names of the jurors and says, I'm agreeable to the juror, I've reviewed it with my client and I accept the jury. So it sounds like he changed his mind with respect to any objections that were made. And that's actually, to me, I don't understand why that's not part of the context as well. In addition to everything that Justice Kennedy has said, when this judge is hearing that, why would he ever think that you were trying to raise an objection to something that you had abandoned or changed your mind about.
Well, Your Honor, again, timing is important.
Yeah.
Because that was the last juror that was challenged, and so then the court read out, here are the jurors that we have. It really is just a matter of, it's a pro forma, yes, we agree, we accept. At that point, really, what could the trial lawyer have done? He could have said, no, I want to say again, I object.
Well, but
You
that
know,
happens.
oh, I strenuously
But
object.
that happens, that's your obligation under the current state of the law, which is to object. So if you're going to impanel the jury, and assuming that the jury's going to be sworn, there's nothing in the record to indicate that he wasn't going to swear in the jury. So the jury's about to be sworn in, you have to object under the law right now. If there is an objection that you have, that's your obligation as either the state or defense counsel. So,
Well, Your Honor, as it has been indicated, the general practice is not to swear the jury in. If the judge had sworn the jury in, as he did, and as the
so
judge
my-
did in
my-
Bakari,
My view always as a trial lawyer was that you had the jury sworn in. It was very unlikely that a jury was not sworn in once the jury was selected. I call that a rookie mistake by a trial court judge.
yes, Your Honor.
I know that this issue wasn't raised, but do you see a problem at all in the fact that a trial lawyer can give an extensive proffer on the record in support of its race-neutral reason, and that somehow an objection that there's nothing in the record is sufficient to raise any issue when there's been a proffer on the record?
I'm not certain that I follow the question, but my
Maybe it's a
understanding
bad
is
question.
that the rulings of this court is that the race-neutral reason has to be in the record, because otherwise the judge has no way of ruling.
I know, but in every other context, we would accept a proffer as a basis on the record, as long as the proffer was made on the record. And of course, the burden of persuasion is on the party objecting to use of the peremptory challenge. And the issue is genuineness. So if in a normal world, if the party said, well, you know, I think notwithstanding the proffer, this is not genuine, they would have a duty to do something to meet their burden of persuasion. Isn't it problematic that they don't have to actually meet their burden of persuasion in response to a proffer, an extensive proffer of what happened on the record? Isn't that problematic?
Not under the facts of this case, because the way this court has held in Dorsey, it has to be on the record. So the prosecutor's assertion that, as Judge Makar put it, a juror had given her the stink eye, that isn't sufficient because there's nothing in the record. Now, a proffer would still have to be proven. There would have to be some...
Under Dorsey, that's correct. That is a 4-3 decision. But
Yes, Your Honor. So if the court has no further questions, we ask this court to approve the decision of the First District Court of Appeal.
I would first like to address some of Justice Luck's concerns, and I want to talk about when I was in the trial court, I was actually a defense attorney, and one of the issues with you saying that they should just have to object once is how it works is oftentimes you get to talk to your client a little bit about who you want and don't want, but you don't know what the prosecutor is going to do. And a lot of times, like these parties were all at sidebar with the defendant, when the prosecutor does something like tries to remove someone, the lawyer's initial response is to say, no, you can't do that. This is improper. You don't usually stop and talk to your client. Oh, by the way, are you okay with me doing this? So what happens is you do this, and then sometimes you go back to your client, and he says, hey, guess what? I didn't really like that juror either. Or what I heard more commonly, I like the juror we're getting better than the juror that she's removing. And they're happy, and the change happens because of you conferring with your client. Your client isn't always as into your legal objection as you are.
It's a great argument for abandonment, and that may be the right way to go here. I just don't, it's hard for me to understand the rule of a second objection renewing the same exact objection that was there. I don't know that it explains that, but I understand what you're saying.
Yeah, and then also, I would also like to raise that you were saying you interpreted the defendant's statements differently than myself and perhaps some of the other justices.
Perhaps
But
so.
do you think that a trial judge should have to try to figure out what a lawyer means. Shouldn't a lawyer have to be specific enough, precise enough, that we don't have to guess what they mean? That's kind of the whole purpose of preservation. And in this case, and I'll admit, this is something that I'm very concerned about in general, because I've been seeing, not in jury selection, but this coming up a lot, where, defense counsel says, I object, this is improper, and state says, no, it's not, and gives an argument. They say, okay, I agree, they indicate abandonment, or it gets settled, say defense counsel says, well, I can agree, but only if she argues this. Then all of a sudden, at the end of the trial, defense counsel says, I renew all my previous objections or whatever, and then it's attempted to argue that this undoes what they've done in the trial. And it's our position that when you abandon something or resolve it, that you don't get to revive that by making some generic request at the end, especially since I just don't think that it's reasonable to think that a trial judge would think you were still talking about the issue that you abandoned. But I see that my time is up. We ask that you quash the decision of the First District. Thank you.
Thank you. Thank you.
We thank you both for your arguments. We'll now go to the fourth case on the docket, which is Calhoun versus the State of Florida.